Over the last few years, something unusual has happened in courtrooms, and it's something lawyers and clients are actively asking about. Judges are sanctioning lawyers, not for aggressive arguments, not for bad advocacy, but for citing legal cases that don't exist. And in many cases, the root cause is the same: artificial intelligence. AI tools can now draft briefs that look polished, authoritative, and legally sophisticated. They generate citations, quotations, and case names that appear legitimate. The problem is, some of that case law is completely fabricated. What's important to understand right away is this: courts are not banning AI. Lawyers are allowed to use it. What courts are saying very clearly, AI does not reduce a lawyer's professional responsibility by even 1 inch. When a lawyer signs a brief, that signature still means the lawyer personally verified the law and all the citations. You cannot outsource that duty to a junior associate, and you cannot outsource it to a language model. There are now hundreds of documented cases where courts have sanctioned lawyers, struck filings, or referred attorneys for discipline because hallucinated case law made it into court filings. And while this may sound like a lawyer problem, it very quickly becomes a client problem too. At first, many lawyers treated these cases as outliers, a learning moment that would go away, especially when people got smarter about using AI. That hasn't happened. Instead, courts are escalating. Sanctions are getting harsher, and patience is running out. Judges are making clear this is no longer about novelty. It's about competence. We've seen sanctions imposed not just on solo lawyers, but on mid-sized firms, national firms, and even some of the most sophisticated legal teams in the country. In one case, the court imposed 6-figure penalties after repeated filings relied on fake AI case law. That should concern everyone because it shows these errors don't always get caught in time. And courts are now hinting at something important, something lawyers and clients should both be paying attention to. Responsibility may extend beyond the lawyer who drafted the brief. At least one appellate court has criticized opposing counsel for failing to catch obviously fake citations. That's a quiet but important warning. Silence may no longer be safe. Now we need to shift from lawyers to clients because this is where the risk becomes much more serious and where people are increasingly asking, can using AI waive attorney-client privilege? In early 2026, a federal court decided United States versus Heppner, the first case to squarely address whether a client's conversations with an AI chatbot are protected by attorney-client privilege. The answer was no. The court held that the client's AI-generated materials were not privileged and were not work product. The government was allowed to seize and use them. Why? Because the chatbot wasn't a lawyer, and because its terms allowed data collection and disclosure, and because the client acted independently and not at counsel's direction. The court treated those AI interactions as disclosure. That's the bombshell. And it directly answered the question many clients are asking. Many people assume that uploading a lawyer's memo into a chatbot is completely harmless, and it's just a way to double-check things. Courts are now saying that assumption can destroy privilege, and once privilege is waived, it cannot be restored. So what should clients and in-house counsel be doing, especially as AI tools become part of every day? First, clients should not upload legal advice, strategy memos, or lawyer communications into consumer AI tools. The client uploads the advice into a chatbot and asks, is this right? Or what should I do next? If you have questions, ask your lawyer directly. Clarification is always safe. Uploading advice into a chatbot may not be. Second, assume anything placed into a consumer AI system could someday be read by somebody else. For in-house counsel, this needs to be addressed proactively. Many privilege waivers don't happen because people are reckless, but because no one warned them that the risk existed. Legal departments should issue clear guidance about AI use. In fact, some law firms have begun modifying their engagement letters to expressly caution clients that uploading legal advice into public AI tools may waive attorney-client privilege. underscoring how serious the legal profession views this risk. AI can still be useful, but it must be treated like any other third party, especially when privilege is at stake. Artificial intelligence isn't breaking the legal system. Assumptions are. Courts aren't banning AI, they're demanding accountability. Clients are not being told not to ask questions. They're being warned that how they ask matters. AI can be powerful, but it cannot protect your privilege, your case, or your lawyer's license. Only informed, intentional use can do that.